You may sit. Madam Registrar, could you open the proceedings?
Caribbean Court of Justice, Original Jurisdiction. Hearing of the matter, St. Lucia and Grenada against Trinidad and Tobago. The members of this afternoon's panel are Mr. Justice Witt, presiding judge, Mr. Justice Anderson, and Madam Justice Rajnathli. May we have the appearances, please?
Good afternoon. I am Amoy Warren, appearing for the claimant as senior counsel, and I'm accompanied today by junior counsel, Dede Ramarine, and instructing counsel, Akinola Goodrich.
Good afternoon, Your Honors. My name is Ronaldo Richards. I appear as senior counsel on behalf of the defendant, Trinidad and Tobago. I'm joined by junior counsel, Mr. Dale Nemhard, and we're instructed by Mr. Keely Richards.
Thank you. Okay, well, counsel for the claimants could commence now. Just a moment. You're looking for the submission, the written submissions? Okay, good.
If it pleases this honorable court, as I mentioned, my name is Amoy Gilding, and I will be addressing in terms of reference Part A of the given fact scenario.
Yep.
Your Honors, I stand before you today to present my arguments with the pride of a true CARICOM daughter, with a Vincentian grandparent, a Barbadian mother, and a father born to the Twin Island Republic of Trinidad and Tobago. I am a much welcome consequence of Caribbean integration at its finest. Movement of people and services across national borders, therefore, is a fundamental principle upon which the CARICOM community is built, and the legal framework of the CARICOM single market and economy. And at the center of this legal framework is the revised Treaty of Chaguaramas. Article 7 of the revised treaty is particularly instructive, such that any discrimination on the grounds of nationality shall be prohibited. This is buttressed by Article 45 and Article 46 concerning freedom of cross-border movement of individuals and services, and also Article 9 with respect to the general undertakings of member states, specifically to abstain from any measure which could jeopardize the attainment of treaty objectives. Your Honors, a magnificent attempt towards the development of regional integration, supported by quality homogeneous attorneys at law, was made when 12 member states decided to sign the agreement establishing the Council of Legal Education, where individuals or member states, share a common determination to establish a scheme for legal education and training that is suited to the Caribbean, where persons receive a legal education certificate from the Council of Legal Education upon their successful completion of a 2-year rigorous practical training and assessment. However, under Section 15(1)(a) of the Legal Profession Act of Trinidad and Tobago, if you are a citizen of Trinidad and Tobago, you are no longer required to obtain a legal education certificate to practice law within the country. The effect this has is that once the qualifications in Section 15(1)A are obtained, such persons are equally entitled without qualification or restriction as the holder of a legal education certificate. This is completely opposite to the scheme for legal education and training that is set out in the principal legislation, particularly but not limited to Article 4 and Article 5 of the agreement, as it concerns the standardized qualifications and admittance into practice. But Section 15(1)A undermines the legal scheme for training and education that's suited for the Caribbean. Instead, it promotes discriminatory treatment of the brothers and sisters of neighboring CARICOM territories. And to add insult to injury, Your Honors, when it is considered that third parties can operate under an entirely different scheme in Trinidad and Tobago, one that does not have the restrictions that are imposed on CARICOM nationals. The implication is abrasive and concomitant of post-colonial prejudice.
Sorry, when you
As
say
it
third
implies-
parties, sorry, Counsel, when you say third parties, are you saying non-CARICOM nationals?
Yes, Your Honor.
I see, okay.
The implication is concomitant of post-colonial prejudice, as it implies that persons with qualifications obtained in England are more favored than a West Indian graduate. This quandary begs a question. Where the agreement allows for discriminatory treatment, does that not bring it in opposition with the revised treaty? And if so, is there not an obligation for us to interpret the treaty or interpret the agreement in a manner in which brings it in line with the revised treaty? The existence of Section 15(1)A suggests that the agreement allows for the discrimination because it...
Could I take you back to the question I asked, sorry, a moment ago? I'm looking at 15(1)A, and it speaks about a national of Trinidad and Tobago, not a non-CARICOM national.
Could you repeat the question
Yes,
for me, sir?
I thought you were, in answer to me earlier, you said that non-CARICOM nationals could benefit from the pathway opened by Section 15(1)A. Am I right?
I'm saying that they, yes, also the third parties, they can benefit from an entirely different regime, separate and distinct from the CARICOM nationals.
And
They
when you
can-
said third parties, you were saying non-CARICOM nationals.
CARICOM nationals.
Yes, but what I'm
yes.
saying is that 15(1)A speaks in terms of a national of Trinidad and Tobago, who by definition would be a CARICOM national.
Yes.
Yes.
So what I am indicating is that third parties are being favored over our CARICOM nationals in respect of their ability to practice law in Trinidad and Tobago without a legal education certificate, when a legal education certificate is required for all other CARICOM nationals, except Trinidad and Tobago nationals, under Section 15(1)A, who can practice in Trinidad and Tobago without the need for obtaining a legal education certificate. And the same stands with respect to the third parties, who only need to do a 6 months internship in a law firm and produce a LPC.
But is that based on the same provision or another provision of the Act?
This is on the same provision, so Your Honor.
Because this speaks about the national of Trinidad and Tobago. I don't, where do you see then third or probably English? I know that there are English attorneys that can practice here without an LEC, but is that based on 15(a)(1) or another provision?
Well, what I am focusing on the submission is that the differential treatment that is afforded to CARICOM nationals can be seen where third parties, excuse me, where third parties are given that opportunity to be admitted to the bar and to practice law in Trinidad without the need for the LEC, which is a restraint which is placed upon CARICOM nationals. Like, they have to obtain an LEC in order to practice law in Trinidad and Tobago but Trinidad and Tobago citizens do not. And these third parties with a qualification that is obtained in England, for instance, they don't have to obtain a legal education certificate. So this is differential treatment with respect to the CARICOM citizens, other CARICOM citizens of other CARICOM territories who are required to have one.
So that's even another kind of discrimination. But we are focusing now on, apparently, on the difference of, on the one hand, nationals of Trinidad and Tobago, on the other hand, other CARICOM nationals.
Yes, sir.
Yes.
Because the idea is that the differential in treatment without a legitimate aim or without reasonable justification amounts to discrimination. And that is where we are going with the claimant's arguments.
And what do you say about the justification, ma'am?
Pardon me?
What do you say about how Trinidad and Tobago has attempted to justify their actions?
It is submitted that Trinidad and Tobago has failed on both limbs of their reasonable justification test. It is submitted that it does not have a legitimate aim, while having a legitimate aim in 2000, based on the Attorney General's opines in the case of Hadid. Those are not relevant now, 23 years later in 2023. The claimant has proved that she's been prejudiced with respect to exercising and enjoying her community rights and her right to be protected against discrimination. And the claimant is adamant that Trinidad and Tobago has breached her community rights. That is under Article 7 of the revised treaty, such that she was discriminated against on account of her nationality. And this is something that the revised treaty abhors.
Yeah, please.
Of course, Section 7 is not a standalone right, as you're aware. So
Yes,
when you
Your
say
Honors.
that her Article 7 rights were abridged or infringed, would you want to go further?
Well, her community rights in respect of Article 7. Article 7, yes, is not a standalone article, but it must be understood and read in tandem with the rest of the provisions within the revised treaty. Article 45 and Article 46, while they might not be exactly the breach that the claimant is claiming, they do provide a supporting role in respect of understanding the treaty as a comprehensive whole and the aberration that the treaty has with respect to discrimination and discrimination against CARICOM nationals.
So those are the ones you're referring to, 45 and 46 in particular, that
We have
those
the-
substantive rights were breached by the breach of Article 7?
Yes, Your Honors.
Yes, okay. All right.
Now, in Cabral Douglas, the court said Article 7 is not a standalone provision, but rather was adopted to ensure that the rights inuring expressly or by necessary implication upon persons of the community were not thwarted because of discrimination on the basis of nationality. So these expressly or by necessary implication formulated rights, what are the rights in this particular case?
Well, while Section 15(1)(a) does not physically restrain the claimant from entering Trinidad and Tobago, it is submitted that Section 15(1)(a) establishes economic barriers as it creates distinct advantages for citizens of Trinidad and Tobago who wish to practice law, but to the detriment of other CARICOM nationals who are not afforded those same luxuries. Having no requirement to get an LEC, you are able to provide legal services in a shorter space of time, and this invariably creates opportunities for financial enrichment and stability, which other CARICOM nationals are not afforded.
Sure.
And this begs the question, as I mentioned before, if the agreement is in opposition with the revised treaty, shouldn't we interpret it in a manner in which it is? And the existence of the section and allowing member states to introduce their own statutory rules for admission to practice, what then is the purpose of a legal education certificate? If Trinidad and Tobago citizens do not need it, why do other CARICOM nationals? I'll tell you why. To give efficacy to the development of quality attorneys at law who receive the same standard of legal education and training and who are worth their weight in gold and can be competent and are able to support a Caribbean jurisprudence which the region is striving towards.
Well, as you know, this matter was considered fully by the Court of Appeal here in Trinidad and Tobago, and the Court of Appeal concluded, among other things, that the alleged discrimination contrary to the Constitution did not exist. And it gave reasons as to why it thought that there was no discrimination under the Constitution of Trinidad and Tobago. The defendant has also cited that case in its defense. How would you respond then to the findings by the Court of Appeal in Trinidad and Tobago?
Thank you for your question, Your Honor. The case of Hadid, while important, has no relevance because it was domestically tried. We are concerned with international obligations and the international obligations of Trinidad and Tobago. It is my humble opinion that had the matter been referred, it would have had a different outcome, possibly. Mm-hmm. And with respect to the instant matter, the claimant is able to show that exercise of her community rights were prejudiced, and she is able to show that the defendant has not given a reasonable justification, or I should say the justification that the defendant has given will not withstand this court's scrutiny.
Mm-hmm. Of course, we have looked at this question of how to treat with domestic decisions which are relevant to issues before us. And we did that, for example, in the case of Tomlinson. And I thought we said in that case that we would, in fact, pay some deference to the decisions made by domestic courts on issues that we are being asked to pronounce upon. How do you square what you have just said with that dictum coming from the Tomlinson case?
Thank you for your question, Your Honor. Unlike Maurice Tomlinson, our claimant is able to show prejudice. Mm-hmm. 23 years, a Section 15(1)A operation is prima facie state practice. They have not provided a legitimate aim for this differential treatment and completely blocking all other CARICOM nationals from entry under Section 15(1)A cannot be considered proportionate by any means.
You're speaking of entry into the profession.
Yes, please.
Yes.
Mm-hmm. So, yes, we take the court's opinions in Tomlinson, and we understand that domestic or member states have the ability to make their own laws domestically. But we also have to remember that Trinidad and Tobago has admitted the original jurisdiction of this court, and the CCJ is entitled, if not required, to adjudicate on allegations of breaches to community law. Mm-hmm. Mm-hmm. And I submit that this is such an occasion that needs the court's scrutiny.
Would you put any weight on the fact that in Trinidad and Tobago, in the Court of Appeal, they were concerned about the issue of discrimination on the basis of race, origin, color, religion, or sex, whereas Article 7 is not concerned with those concepts? Is that a relevant consideration to distinguish what happened there with what you're asking to happen here?
Yes, the facts are indeed distinguished from the present case. We are alleging, or we are submitting, rather, that Trinidad and Tobago, through operation of Section 15(1)A, is operating in a manner or using its governmental authority in a manner which jeopardizes the attainment of treaty objectives. And the objectives under Article 6, Article 7, Article 9, 45, we're reading the revised treaty as an entire document. It is not, one article is not separate and distinct from the other. The reason Article 45 and Article 46 are important with respect to the claimant is that, as I mentioned, while it is not restraining her from entering the country physically, it is placing a disadvantage, a restriction on her to be able to financially provide legal services and for the financial enrichment and stability that other Trinidadian citizens are being afforded.
Yeah.
And if that is the case, and Trinidad and Tobago citizens are being afforded that, then other member states should also be afforded those.
I'm glad you referenced governmental authority, because I thought that was another defense that the Trinidad and Tobago government was putting forward. That is to say that the enactment and the operation of Section 15(1)A were pursuant to Article 30 of the revised treaty, which enables the state to take governmental activity in certain circumstances. So how do you respond to that?
Thank you, Your Honor, for the question. The defendant's use of Article 30 is incorrect. Article 30, the scope does not allow Section 15(1)A to be hidden or to be used as justification to limit the rights or the exercise of community rights of persons. Article 30 does not extend to attorneys at law in their private capacity. As auxiliaries of law, they have no allegiance or oath to the state. We are not.
They're officers of the court.
Well, we have allegiance to the court.
Yes,
We have allegiance to our client.
yes,
We have allegiance to the administration of justice.
yes.
I submit that private attorneys at law in their private practice do not fall within Article 30. And therefore, the defendant's use of Article 30 is incorrect, misfounded, misguided.
You have some case law to back that up?
In the case of Shanique Myrie, we can also use that with respect to the scope of Article 30.
Go ahead, ma'am.
And I think you're citing a case here from the European Court, Pulu, or is that in a different context?
Well, no, we did cite that case. My junior counsel, she will be elaborating on that section
Okay.
more thoroughly for you, unless you would like me to.
No, that's fine if it is being dealt with. I'm interested, of course, to hear how she will pronounce the name of the defendant, but which is difficult German. But anyway, you continue.
Since the work of the community is affected through the bodies and organs of the community, as provided under Article 10, and these reflect the will of the community, as opined in the case of Doreen Johnson and against Carrie Cad. The subject matter of today's claim falls squarely within the ambit of quoted. Quoted. If quoted is not satisfied that a member state is applying these restrictions in line with paragraph 6 of the article, and this is Article 47 of the revised treaty, they can make recommendations to the member state adversely affected. But more importantly, under paragraph 6 of the article, this is Article 47 of the revised treaty, member states have a duty to minimize the damage to economic or social cohesion and to prevent the unreasonable exercise of these restrictions. restrictions which could impair CSME, which could impair the further development of the CARICOM community. And furthermore, COTED has the ability to determine the appropriateness of these restrictions and whether or not they should be continued.
Are you saying COTED should be a party to these proceedings?
While not being a party, sir, I think COTED should be paying very close attention, and they may need to pay Trinidad and Tobago a visit
You didn't
with
join,
respect to the subject
you
matter.
didn't join the community?
Pardon me?
Did you join the community?
Trinidad and Tobago?
Yeah,
Yes.
the community.
If they enjoy the
Did
community.
you
If
join?
as claimants?
Yes.
Yeah.
Join CARICOM.
I'm
You're
not,
complaining about COTED.
not complaining about COTED,
Oh, I see.
just underlining its authority and underlining the need for it and the need for COTED to examine what has been transpired in an attempt to safeguard the integrity of the Caribbean and the uniform application of community law.
It's a friendly advice.
Yes, I suppose.
Yes.
But anyway, we're not dealing with advice, friendly or not. We're dealing with the case. And I think you are out of time now.
I am.
So I think it's time that you conclude. We asked you some questions, so we are a little flexible with the time, but I think
Thank you.
you should conclude now.
And could I just ask one more question before you conclude?
Sure.
When we're talking about, you and I, Article 30 and the scope of Article 30, as you know, Article 30 is concerned with activities involving the exercise of governmental authority. In fact, you're the first one to mention that phrase. Would you consider that the enactment of legislation is an activity involving the exercise of governmental authority?
Oh, for sure. Yes, definitely.
Yes.
Trinidad and Tobago can exercise their governmental authority and enact the legislation that they wish.
Right.
However,
Yes.
they must bring it in line with the revised treaty.
Okay.
They must make sure that it does not jeopardize the attainment of treaty objectives or the CARICOM community or hamper the furtherance of CSME. We're all in this. This is a regional exercise.
Yes, yes. Before we go off on the common exercise, I was just concerned about Article 30, because you see, what it does is to exempt from the scope of Chapter 3, including 45 and 46, which you mentioned, activities involving the exercise of governmental authority. So if you agree that the enactment of Section 15(1)(a) by the legislature is in fact an activity involving the exercise of governmental authority, would that exercise not exclude from our jurisdiction the examination of Section 15(1)(a)?
No, Your Honor.
No, okay.
While the revised treaty may allow for certain restrictions, Article 37 of the treaty makes it clear that member states shall abolish discriminatory restrictions.
Yes, Counsel, but what I'm saying is that 37 is found within Chapter 3. And activities involving the exercise of governmental authority are excluded from the scope of Chapter 3, including 37 and 45 and 46. So if you agreed, and you readily agreed earlier, that the enactment of legislation is an exercise of governmental authority, where does that leave your suggestion that Trinidad has breached 37 and 45 and 46?
Well, there's a balance that must be struck. Trinidad and Tobago still has to acknowledge its treaty responsibilities, its obligations under its international treaty. And we've seen that the CCJ is not afraid to remind member states that when their domestic legislation is not in line with the revised treaty, that they must bring it in line with the revised treaty. Shanique Myrie, the case of Survey and Neverins, they also show, all of them confirm the power the CCJ has to hold member states accountable in their decision to ratify and implement the treaty. Why do it if you don't intend to uphold your obligations?
Yes.
Ma'am, this court recently issued a judgment in the matter of Ellis Richards against the state of Trinidad and Tobago. Were you able to look at that? I know it was recent.
Unfortunately, no,
Oh,
Your
I see.
Worship. They did not cover that in the research in my current submissions, but I'm heeded and I will read it as soon as I am finished.
We're having a look at your research here, actually. And thank you. I'm so sorry for delaying your conclusions.
Yes.
Please, yes.
It is my submission that Trinidad and Tobago has discriminated against the claimant on account of her nationality. And I respectfully ask this honorable court to declare that Trinidad and Tobago has definitely breached those obligations under the revised treaty by enforcing domestic legislation under Section 15(1)A of the Legal Profession Act, which runs directly in contrary with Article 7 of the revised treaty. And I ask this honorable court to call on the state of Trinidad and Tobago to bring its legislation in line with the revised treaty. If it pleases this honorable court, that is the end of my submission.
Thank you.
I now
Very
invite
much.
junior counsel to come and
Thank you.
Thank you.
Ms. Remner Ryan.
Good afternoon, Your Honours.
Good afternoon.
Good afternoon.
If it may please the Honourable Court, I would now address the breach of the agreement establishing the Council of Legal Education, as well as the breach of the revised Treaty of Chaguaramas. I intend to show today that the state of Trinidad and Tobago, by their enactment and their operation of Section 15(1)A of the Legal Profession Act of Trinidad and Tobago, has breached not only the CLE Treaty, but the RTC as well. But what does the CLE Treaty entail? Article 5 of the CLE Treaty sets out that each participating member state would see and recognize a person holding the Legal Education Certificate, the LEC, as having fulfilled the requirement for admission to practice law in its territory. And following from Article 5 of the CLE Treaty, the governments of those participating states would have been required to enact legislation making the LEC a mandatory and exclusive qualification for the admission to practice law. But Section 15(1)A of the Legal Profession Act, however, removes this requirement, and instead, it allows for several alternative paths to become a practicing attorney at law.
Did you say mandatory and exclusive?
Could you repeat the
Did
question,
you say
Your Honor?
mandatory and exclusive? I thought you could have additional qualifications.
Yes, Your Honor. Article 5 does acknowledge that no territory could be excluded or prevented from imposing additional qualifications as a condition to the admission to practice law.
So it's not
But-
exclusive then? Okay. Mandatory perhaps, but not exclusive.
Guided, Your Honor.
Possibly, yes.
Yes. What counsel for the claimant is submitting today is that a strict interpretation of that term, additional qualifications, suggests to us that the LEC is nevertheless the base requirement, so that states may choose to impose qualifications further to the LEC, and they cannot be prevented from doing so. But to interpret Article 5 as allowing for those states to replace this qualification with alternative paths, that would ensure that Article 5 of the treaty is not complied with.
So do you want Trinidad and Tobago to comply with Article 5?
Yes, Your Honor.
So you want them to put back the requirement of an LEC?
Yes, Your Honor.
Is that going to help Mrs. Khadid? Because she wants to make use of that exception. She says, I can't use it because it's limited to nationals of Trinidad and Tobago. But if you are arguing that it should be put back, it will not help her, at least. You agree with that?
Your Honor, what the counsel for the claimant is submitting today and what we are calling on the court to do is to ask Trinidad and Tobago to bring their domestic legislation into conformity with the treaties that they have voluntarily signed on to,
Yeah.
that being the CLE Treaty and the RTC.
So the state of Grenada, who you represent, is not espousing particularly her claim, because she doesn't want the LEC as a requirement. She wants it open to her to do without that. Isn't that so?
Yes, Your Honor, but we are submitting that the fact that Trinidad and Tobago is not allowing this permission for alternative paths to non-nationals contravenes its treaty obligations, and that is the focus of my submission today.
Yeah.
So,
ma'am, can Mrs. Khalid practice in Grenada
in Grenada,
under your law?
Your Honor, the issue before the court today is whether Ms. Khalid can practice in the state of Trinidad and Tobago. And I'd like to focus on the obligations with respect to Trinidad and Tobago in that regard.
So you're not able to assist us with that?
In terms of Grenada, at this time, no.
Okay, thank you.
But the defendant pointed out in paragraph 11 of the defense, section 17.2 of the Legal Profession Act of Grenada, and that would seem to be also kind of a not complying with Article 5 of the agreement. Now, they made that point. I suppose you would have looked at it.
Your Honor, Grenada has, similar to Trinidad and Tobago, provisions in alignment with Section 15(1)A of the Legal Profession Act of Trinidad and Tobago. So in that regard, the arguments that the counsel for the claimant is submitting today with respect to Trinidad and Tobago might also be applied to Grenada.
So
But they
would
have not brought any cross claims against you, have they? Have they brought any counterclaims against you in respect of what they are alleging you're doing wrong?
To my knowledge, there is no counterclaim to that effect.
And you would have knowledge, would you not?
Correct, Your Honor. If I might be permitted to continue.
But isn't then that claim being like the pot calling the kettle black? Because you're saying, well, Trinidad is not complying with Article 5 of the agreement. But if you are conceding that your client is not complying with that either, isn't that a bit strange?
Your Honor, can you rephrase the question being asked?
Well, you know the saying, the pot calling the kettle black?
Yes, Your Honor.
Yeah, so if you make the same mistake that you blame the other, isn't that a little awkward?
Your Honor, we submit that it is not a case of the pot calling the kettle black. Instead, Section 15(1)A seeks to discriminate against, as my senior counsel would have pointed out, the non-nationals of Trinidad and Tobago. And Mrs. Dion Khalid, the claimant before us today, is seeking to enter Trinidad and Tobago with respect to practice that. I'd look to the case of Vlasopolo against the Ministry of Justice, Federal and European Affairs, which I've taken the liberty of translating to English for our ease here today.
I think you are very wise to do that. Let me just, for your education, tell you how it is said. It's Vlasopolo versus Ministerium für Justiz, Bundes- und Europa-Angelegenheiten, Baden-Württemberg. If you can't pronounce that, we have full comprehension for that.
I am guided, Your Honor. That very case, the European Court in that case held that in circumstances like these, the state should have consideration for the equivalence of diplomas and certification. and that in doing so, they should ensure that steps are taken towards having procedure in place to properly compare those certifications and those qualifications so that they have an even ground. The state of Trinidad and Tobago today pays no regard to that equivalence of qualifications, and we are submitting that they ought to. We look at the case of the Attorney General of Trinidad and Tobago against Diane Hadid, where the state of Trinidad and Tobago sought to justify their enactment of Section 15(1)A of the Legal Profession Act. They sought to justify it by indicating that TNT nationals were facing some hardship with respect to the limited spaces available to Trinidad and Tobago nationals at the law school. The law school, of course, being a prerequisite to the obtainment of the legal education certificate. This begs the question, is it that only TNT nationals are facing this competitive degree program? The answer is no. The reality of competition, global competition, and a competitive market exists across the globe. And in fact, the restrictions applied on that basis also exist across the globe. So that it's not every person who wants to study or who wants to practice in a particular country that is allowed to do so, whether it be in Europe, in the United States, or in Canada. Each country has obligations, they have conditions and requirements for the admission into schools and for the admission into practice. And it's no different in the Caribbean. Now, beyond this misguided justification by the state of Trinidad and Tobago, we submit that Hadid gives us nothing in the way of addressing treaty obligations. Treaty obligations such as Article 8 of the RTC, the Most Favored Nations treatment, which sets out that each member state shall, with respect to the rights afforded under the treaty, afford and accord to another member state treatment that is no less favorable than that accorded to a third member state or a third state. And in looking at this, we go to the case of Shanique Myrie against Barbados, where the right to MFN treatment is actually guaranteed. It's guaranteed that nationals, community nationals, receive treatment by the defendant state that is no less favorable than the treatment extended by that state to nationals of other states, whether it be CARICOM or otherwise. We see from this that Trinidad and Tobago has an obligation under the RTC, an obligation to afford the same treatment to non-nationals as they're affording to nationals.
Well, I think, Article 8 means if a state gives another member state a certain advantage, you have to give all of them the same advantage. 7 is when you give a certain advantage to your nationals, in principle, you would have to give that same advantage. So 7 is concentrated on nationals and the comparison, and 8 is more when I give state A certain advantages, then I have to give it to all of them. For example, if Trinidad would say, well, for 15A1 is open to my nationals and the nationals of Jamaica, well, in that case, 8 kicks in and says, well, if you give it to Jamaica, you have to give it to all the member states. So I wasn't quite clear about invoking Article 8. Under Article 7, I understand, but Article 8, I had a conceptual difficulty with that.
Okay. Your Honor, given that, we are submitting today that if it is permissible for non-nationals to receive this special treatment in terms of they are allowed to have alternative paths to becoming an attorney at law, then that same treatment should be afforded to the non-nationals holding the exact same qualifications. But what we see happening instead is that Section 15(1)A of the Legal Profession Act is allowing more favorable treatment to the nationals of Trinidad and Tobago than it is allowing to non-nationals.
I think we follow you on that point. You had said earlier that you were going to show us how a breach of the CLE agreement resulted in a breach of the RTC. I think one of us interrupted you in your flow. And you may have done it and I missed it. But can you just, for my benefit, emphasize that point again? How is it that a breach by Trinidad and Tobago of the Council for Legal Education Agreement necessarily results in a breach of the revised Treaty of Chaguaramas?
Your Honor, what we are submitting is that the actions by the state of Trinidad and Tobago in breaching the CLE treaty also breaches the revised Treaty of Chaguaramas, such as treaty obligations like Article 7 and 8 of the RTC, and Article 6, which pronounces the objectives of the community. Those would also be breached by Trinidad and Tobago's enactment and operation of Section 15(1)A of the Legal Profession Act.
Now, if 15A1 would have said this is open to nationals of Trinidad and Tobago and other CARICOM nationals, would that not also be a breach of the CLE agreement?
Yes, Your Honor.
But would that then be also a breach of the RTC in that case?
In that case, we submit that where it is afforded, where the same treatment is afforded to nationals and non-nationals in that regard, the RTC, as it relates to the discriminatory restrictions, would not be breached.
So the RTC would not be concerned that there is a double breach then? Is that what you're saying?
Well, the effect of that addition into the legislation would ensure that the state of Trinidad and Tobago is not in fact breaching its rights as regards discrimination towards non-nationals.
But what about the CLE agreement?
In that case, if it were the case that only these alternative paths could guarantee you admission to practice law in the territory, then that would be a derogation from the CLE treaty, because the CLE treaty guides us that the legal education certificate ought to be the base requirement. And we see from the Legal Profession Act that non-nationals would be required to have this legal education certificate. It is only the nationals of Trinidad and Tobago that are afforded this special permission.
And you mentioned Article 6. How would breach of the CLE result in a breach of Article 6 of the RTC?
The Article 6, with respect to the objectives, shows us that some of the objectives of the community include improved standard of living and work, as well as the full employment of labor and other factors of production. This is seeking to promote the highest level of efficiency with respect to the production of goods and services, so that this is actually an essential component to the economic and the social development of community nationals. And a breach of the CLE treaty by Trinidad and Tobago's actions in operating Section 15(1)A would go against the objectives of the community, because the objectives suggest to us that there should be standardized education, standardized qualifications, and where we permit one sector of persons to be afforded different treatment than another, that goes against the standard being set by both the CLE treaty and the revised Treaty of Chaguaramas, by the Caribbean community itself.
I see. Thank you.
Thank you. You're out of time, but you may conclude now.
In concluding, we, counsel for the claimant, submit to this honorable court that the state of Trinidad and Tobago, by its implementation of Section 15(1)(a) of the Legal Profession Act, has breached not only its obligations under the CLE Treaty, but has also breached its obligations under the RTC. And in that regard, we humbly ask this Honorable Court to call upon the state of Trinidad and Tobago to bring its domestic legislation, specifically its Legal Profession Act, into conformity with the RTC. If I might assist the court no further this time, this is the extent of my submission.
Thank you very much.
Thank you.
Thank you.
I may now call on counsel for the defendant state. You can see this is truly a Caribbean event. Jamaican lawyers defending the state of Trinidad and Tobago.
May it please the court, my name is Ronaldo Richards and I appear as senior counsel on behalf of the defendant, Trinidad and Tobago, and I'm joined by junior counsel, Mr. Dale Nemhard, and we're instructed by Ms. Akeelia Richards. I'll be arguing that Section 15(1)(a), this section of the Legal Profession Act, the LPA, does not breach Article 7 of the revised Treaty of Chaguaramas, and in any event, it is safeguarded as an exercise of governmental authority under Article 30, paragraphs 2 and 3. Junior counsel will submit that this honorable court does not have jurisdiction to adjudicate a breach of the agreement establishing the Council of Legal Education, the CLE agreement, and even if it did, the section conforms with the CLE agreement. With the leave of this honorable court, I'll begin my first substantive submission. St. Lucia has not discharged its obligation to prove discrimination. At paragraph 84 of this honorable court's judgment, in Shanique Myrie and the State of Barbados, 2013 CCJ 3 OJ, the court concluded that there's a burden on the claimant to prove through facts a prima facie case of discrimination. St. Lucia's reliance on the existence of the section alone does not discharge that obligation. And for this point, we turn to paragraph 29 of the Maurice Tomlinson and the State of Belize decision, where this court concluded that there are 3 points that should be noted. Firstly, there's no general rule that the existence of a treaty that, the existence of a legislation that may be incompatible with a state's treaty obligation means that the legislation constitutes a breach of the treaty obligation. And in determining this, this honorable court should have regard to factual elements of state practice to determine if there's a breach in existence. The defendant acknowledges that while the section, being an enactment of the legislature, is a factual element of state practice, it is not discriminatory because it does not accord to mislead treatment that is worse or less favorable, and in any event, it has an objective and reasonable justification.
Would you, Mr. Richards, in all seriousness, equate what happened in the Shanique Myrie case with this situation here, Section 15(1)(a) of the LPA of Trinidad and Tobago?
Thank you, Your Honor. It's not an equation, it's not We're not saying that this case is the equivalent of or equivalent to the Shanique Mary decision.
So if it is
but
not,
the
then why would the test in Shanique Mary be applicable here?
Because the test which is developed to interpret Article 7 is applied to all cases involving an alleged breach of Article 7.
In Shanique Mary, as I understood it, and correct me if I'm wrong, I gather there was quite a lot of Jamaicans who arrived on this flight from Jamaica seeking entry into Barbados, 28, I believe it was, and 2 were denied entry, including Miss Mary. There are other people who arrived from other jurisdictions for entry into Barbados who were also denied entry. So the question arose as to whether Miss Mary had been denied entry on the basis of her nationality only. And the court said, well, you know, you have to come with evidence, statistical evidence and otherwise to show that that is what occurred. In this case, ex face on its face, Section 15(1)(a) speaks to nationality, and it says that unless you are national of Trinidad and Tobago, you cannot enter through this pathway into the practice of law in Trinidad and Tobago. So why would we apply what happened in Shanique Mary to this case here?
Your Honor, because the test from Shanique Mary is applicable to all cases involving a breach. So while we acknowledge that there were differences in terms of there is a question as to whether there was true discrimination in the Shanique Mary decision, the test which requires that the claimant proves discrimination, and not only that, Your Honors, but the test further requires that the difference in treatment must be worse or less favorable, and there must be no objective or reasonable justification. And this test has also been utilized by this Honorable Court in subsequent cases, such as the Rhodesia decision, Your Honors, and also Rhodesia in the state of Guyana, and also this Court's decision in Cabral Douglas.
But there can be no doubt, counsel, can there be, that Mrs. Khalid received less favorable treatment than a Trinidadian national? Can there be?
No, Your Honor.
No. Okay. So the only other thing then would be whether there was an objective justification.
Sorry, Your Honor. I feel I might have misheard your question. So I think my answer is yes. The difference in treatment is not worse or less favorable for 3 reasons. One, Ms. Khalid being the holder of a CARICOM Skilled National Certificate, the CSNC, for the last 11 years, and a citizen of 2 CARICOM countries, is able to practice in Trinidad and Tobago, provided she meets the qualifications set out at Section 15 of the LPA, as in or Article 4 of the CLA agreement. And additionally, Your Honors, relying on the Trinidad and Tobago Court of Appeal decision of Diane Jamile Hadid, of Attorney General and Diane Jamile Hadid, that court concluded at paragraph 45 that there's an inherent difference between nationals and non-nationals, because nationals are entitled to the patrimony and resources of their state by right, while non-nationals do not. And most importantly, Your Honor, the handicap that nationals who benefit from this section face in that they're only able to practice in Trinidad and Tobago only. Ms. Khalid, if she meets the qualifications set out at Article 4 of the CLE, is able to practice in any of the CLE jurisdictions, and therefore there's an argument to be made that she's in better standing in terms of being able to supply her legal services across the region than those nationals who benefit under this section, Your Honor.
She doesn't feel that way, obviously.
Yes, Your Honor, we recognize that, and we also submit that this court, in determining if the section constitutes a breach, should have regard to local decisions on this matter. And so we also ask you to turn your attentions to paragraph 64 and 72 of the Hadid judgment, where that court concluded, using the similar test as Shanique Mary, on similar facts as this instant case, concluded that there was no discrimination. And even though, Your Honors, that the context under which that decision was made was the Constitution of Trinidad and Tobago, the test being the same, the facts being the same, we ask this court to come to a similar conclusion. Your Honors, on the point of an objective and reasonable justification.
If I may, I think in Myri, we also made it clear from the perspective of the revised treaty, yes, there is a difference between nationals and non-nationals. But it may have been that the Court of Appeal has not read this judgment, but in this judgment, the court clearly said that gap between nationals and non-nationals, through the Treaty of Chagaramas, the revised treaty, that gap between nationals and non-nationals but CARICOM nationals is much less than between nationals and third country nationals. So yes, there is still in many respects a difference, but CARICOM nationals and nationals of a member state, really are very close. So that is an element that, from our perspective, of course, makes a difference. Now, whether that is enough, that's another question, but you can have an opinion on that. But there is less difference between nationals of, let's say, in this case, Trinidad and Tobago, and other CARICOM nationals. Although it has been pointed out that UK nationals may have who are not part of CARICOM, may have an advantage here, but that is outside of this particular issue. Please continue, or maybe you want to react on it.
Yes, Your Honor. So the defendant would submit that while there is a narrowing of the scope in terms of the difference between nationals and non-nationals at the community level, the difference in treatment is still not worse or less favorable. And as I will come to now, Your Honor, the enactment of this section also has an objective and reasonable justification. A reasonable and objective justification has been interpreted by the European Court of Human Rights, the ECHR, in Carvalho Pinto de Sousa Moreira in Portugal, decided July 25, 2017 at paragraph 44, of being one that pursues one, a legitimate aim, and two, is proportionally achieves its objectives. The section pursues a legitimate aim in that it was responding to a need to alleviate the hardship faced by Trinidad and Tobago nationals in being admitted to the law school and ultimately to the bar. That hardship was caused by two things. One, the difficulty at the time and the limited spaces in getting into the faculty of law compelled students who still wanted to obtain an LLB but could not gain a place to study overseas. When they returned to the region, due to the automatic admission of the ULLB students, there were limited spaces available at the law school. And so Trinidad and Tobago was faced with a situation where its own nationals, having studied overseas, could not practice in the country of their nationality. And so there was a requirement for them to act. Your Honors, the section is also proportionally achieves that objective. Because one, it does not completely preclude Miss Khalid from being admitted to the bar in Trinidad and Tobago. It only carves out this avenue for its nationals. And secondly,
Which she can't enter.
Right, Your Honor, because she's not a national of Trinidad and Tobago.
So there is differentiation between her and nationals of Trinidad and Tobago.
Yes, Your Honor, but that difference is not less or worse.
I beg your pardon?
The difference in treatment that she's facing
Yes.
is not less or worse.
You wouldn't say it's less favorable?
No, Your Honor, for the reasons which I've outlined earlier.
Your friends for the claimant say that your justification that you mentioned, the first part, that is no longer relevant. What do you say? That's how I understand their submissions. What do you say about that? Mr.
Your Honors,
Richards?
we submit that there's still while we acknowledge that there's certainly more than one faculties of law, having studied at the faculty in Mona. I know firsthand you don't need to go to K-Ville alone anymore. But, Your Honors, there's still a difficulty faced by Trinidad and Tobago nationals in being admitted to the law school due to the limited spaces. And those nationals who study overseas and want to be admitted to the bar are able to be called provided that they meet the qualifications set out at under the section. Your Honors, it also bears repeating that those nationals who benefit from the amendment are only able to practice in Trinidad and Tobago.
I'm glad you said that, because you said it before, did you not?
Yes.
Yes, and I'm not so sure about that, because I seem to have read from some of the papers submitted earlier, Section 17 of the Grenada, I think it's the Legal Profession Act or the equivalent statute, which allows persons who have been called in Trinidad and Tobago, in effect under Section 15(1)(a), to practice in Grenada under some reciprocal recognition arrangement. So I would take that under advisement. I'm not 100% sure, but I did hear you make the point twice now, so I thought I would respond to it. Yes.
Yes, Your Honor. The reciprocity that you're speaking to would be a reciprocity provided for by the CLE agreement, not the RTC. And therefore, if there are any, those submissions would be made by junior counsel in response to your point.
Very well, yes.
Your Honors, finally, on this point, because the section, finally on this point, the argument was made by the claimant that this section entitles Trinidad and Tobago nationals to practice, and by then that would interfere with the collective thrust of the CLE agreement. While I do not intend to steal the thunder of junior counsel, I'll make one quick submission on this point, that because of the 6-month attachment which is required by nationals who benefit from the section, the thrust which the claimant's counsel spoke to, which was for a collective Caribbean jurisprudence, is maintained, because that attachment has to be done with an attorney who has been at the bar for at least 10 years. Your Honors, if you have no further questions for me on this point...
That attorney could have qualified through Section 15(1)(a) as well?
Perhaps.
Possibly.
Perhaps. But having practiced in the jurisdiction,
For 10 years.
we submit that they would have become acquainted with the jurisprudence.
Okay.
With your permission, I'll move on to my second substantive submission. Your Honors...
Before you do that, I heard you say that if Ms. Khalid would be allowed under 15(a)(1), if it would be possible for her to be admitted under that section, it's not, then she would have more advantages than a Trinidadian national. Did you say that?
No, Your Honor.
Oh.
I said that Ms. Khalid, because of the requirement for her to be admitted under Section 15 of the LPA, meaning she would obtain the qualifications set out at Article 4 of the CLE agreement, she is able to practice in any CLE country provided she meets the requirements to be admitted to the bar. However, those nationals who qualify under this section are limited to practicing in Trinidad only unless they then obtain the Article 4 qualifications.
Yeah, but if it had been open to other nationalities, they would have the same limitation. If she could have entered the bar
Yes.
under this article, which she cannot, but in that case, she would also be limited to practice in Trinidad and Tobago. Is that correct?
Yes, Your Honor.
Okay, good.
The defendant submits on the authority of paragraph 16 of this honorable court's decision in Cabral Douglas and the Commonwealth of Dominica, that Article 7 is not a standalone right, and therefore any breach of Article 7 must be pinned to a breach of another article within the scope and application of the RTC. Claimants in their submissions rely on Article 37, which says that states are required to remove restrictions which may be discriminatory. However, Your Honors, Article 37 is to be read with Article 36, particularly Article 36(4), which sets out the criteria for what it means by supply of services within the region and what sort of restrictions on those services would need to be removed by Article 37. At Article 36(4), it specifies four ways. One, if it's if it's supply of services from one member state to another, supply of services from one member state into another, supply of services through the commercial presence in another member state, or the commercial presence of suppliers through nationals in another member state. We submit that Ms. Khalid does not fall within any of these categories. However, if she could fall in Article 36(4)(d), the sort of services contemplated at 36(4), based on this court's ruling at paragraphs 19 and 35 of Cabral Douglas, are those services which are, 1, temporary in nature, and 2, done for remuneration other than wages. Those sort of legal services, Your Honors, would be services, would be consultancies, for example, or single appearances in matters. Ms. Khalid, being the holder of a CSNC and presumably working in Trinidad and Tobago, at least after she's newly qualified, would not satisfy that requirement. The claimants also rely on Articles 45 and 46. Those articles, Article 45 in particular, prevents states from precluding the hassle-free movement of nationals, of CARICOM nationals into the state. Ms. Khalid, having lived in Trinidad for the last 11 years pursuant to her CSNC, is not affected by this article. But more substantively, Your Honors, even if the section violated those rights provisions, it is safeguarded as an enactment of governmental law, as an exercise of governmental authority. Because, 1, at paragraph 57 of the Shanique Marriage judgment, this court interpreted it to say that states are able to reserve certain public service positions or certain positions which serve the public interest for their nationals. And in this case, even though lawyers, the profession of the law is a liberal one, they are officers of the court, and they assist with the proper administration of justice. And so whether they're in private practice or at the state bar, there's still that expectation of allegiance to the state, which is covered by Article 30.
Would you not acknowledge that there are many lawyers in the state of Trinidad and Tobago who are not nationals of Trinidad and Tobago, practicing with an LEC, but nevertheless. So apparently lawyers in general is not a group that falls under this governmental authority issue. I do think, for example, that judges in the state of Trinidad and Tobago must be nationals of Trinidad and Tobago, and as it is clear from that paragraph 57, that might be a discrimination, if you want to call it that way, but it is allowed. It is put outside of the scope. So, of course, nothing was said about lawyers in general. If it is a fact that there are those lawyers who are not nationals of Trinidad and Tobago, doesn't that kind of indicate that it is not such a group falling on the 30?
No, Your Honor, because the attorneys still are essential to the proper administration of justice, which entitles the state to either a complete reservation, if it so chose, or a partial reservation, as the defendant did in this case, as an exercise of governmental authority.
But what difference does it make in terms of this particular category? They are all lawyers. Most of them have an LEC, but not all. But not all of them, or those who do not have that LEC, are all nationals of Trinidad and Tobago. But it doesn't mean that there is any activity done by lawyers which would fall under this. It's a matter of requirements for admission. But that's a difficulty which I try to wrestle with. Maybe you can help me.
Your Honors, I would say that because those nationals who are called can only practice in Trinidad, it increases the sort of connection that they have to the state, because unlike those nationals who have LECs, their ties to the country might not be as entrenched as those who can only practice in Trinidad and Tobago.
Well done.
We'll consider it.
Thank you, Your Honors.
Thank you.
Thank you. Thank you. So if I can be of no further assistance to this court, these are my submissions, and we ask that you dismiss the claim of St. Lucia with costs to the defendant.
Thank you very much.
Thank you.
Thank you.
That's the first.
Ms. Demott.
Good afternoon, Your Honors. May it please this honorable court, my name is Adelia Nemhard, acting as junior counsel on behalf of the defendant, the state of Trinidad and Tobago. With the leave of this honorable court, I will be making the submission indicating that this court has no jurisdiction to interpret or adjudicate a breach of the CLE agreement, and further, if this court finds that it has jurisdiction, that their enactment and operation of Section 15(1)A of the LPA has not breached their obligations under the CLE agreement or their RTC obligations. May I proceed, Your Honors?
Sure.
On the first point, Your Honors, the defendant submits that this court's jurisdiction, pursuant to Article 211 of the RTC, is limited solely to the interpretation and application of the RTC. Further, Article 216 recognizes that states recognizes compulsory and exclusive jurisdiction ipso facto and without special agreement, again in pursuant to Article 211, which indicates that the interpretation and application of the RTC is the sole premise for this honorable court's jurisdiction.
May I ask, is it possible that in determining the interpretation and the application of the treaty, that it may become possible or necessary to consider other materials other than the RTC?
Your Honors, the defendant submits that on that basis, in some cases, it may be necessary. However, on behalf of my client, and in my client's case, that it has not arisen because, as I will discuss further, the CLE agreement is to be treated as a separate treaty as much as the RTC, and there is nothing that indicates that there is an echo, that the parties intended that the RTC should govern the CLE agreement or in any way interfere with its operation.
Yes, you're cutting me short before we have gotten to the place I wanted to be cut off at. But I was just trying to take you down the road of asking you, assuming you agree with the basic premise that yes, we can use other materials. The next question I was going to ask you is whether we can use treaties to help us to interpret and apply the revised Treaty of Chaguaramas.
Well, Your Honors, if that treaty in its application is regarding a similar subject matter, or if it has been otherwise established that that was the party's intentions, by all means, that is the jurisdiction of this court. However, on behalf of my claimant, I submit that that was not agreed by the parties of the CLE agreement.
Not to cut you short, Counsel, but does it have to be agreed by the parties? I mean, if you look at the Vienna Convention and the law of treaties and customary international law, surely it provides that in interpreting and applying a treaty, it is permissible to look at international rules which are applicable between the parties. I believe that is in Article 31, paragraph 4.
One.
of the Vienna Convention on the Law of Treaties. And I believe we have also quoted with approval that particular provision in the Rockhart case, Chairman?
Rockhart case?
Yes. So why are you saying then that we can't look at the CLE agreement, not to interpret or apply it, but as an aid in the interpretation and application of the RTC?
Well, Your Honors, you can utilize the agreement to interpret the... Could you repeat your question, Your Honors, just for clarity?
I thought you were answering it beautifully.
You can, okay, I will continue then. Thank you
Yes.
for that, Your Honors. You can use the CLE agreement to look at the RTC. However, you cannot use the RTC to terminate or suspend the operation of the CLE agreement, as it is an independent agreement, and no declarations made by this court should therefore terminate or suspend its independent operations.
I don't think anybody was asking for that, though, Counsel. Was anybody asking for that? I thought the best that the other side was asking for was a declaration or a statement that Trinidad and Tobago had breached the CLE. I don't think anybody was asking for the termination or suspension. Furthermore, I believe in a case that we have decided, the Jason Jones case, we did have occasion to mention the Council for Legal Education Agreement, as you well know, ma'am. And there were comments made by this court on the CLE agreement, comments to the effect that parties were obliged to comply with their obligations under the CLE agreement. So we can say something about it, can't we?
Yes, Your Honors, you may say it, as you are learned, and we respect your decisions accordingly. However, in terms of making a declaration over the CLA agreement, the defendant submits that that does not fall within this court's jurisdiction or purview.
So we can say that Trinidad and Tobago should apply or should comply with its obligations under the CLE agreement. Can we say that?
No, Your Honors, on the basis that that would amount to a declaration and is outside the scope of this court's jurisdiction, because it would involve using the RTC to interpret the CLE, but the CLE agreement
We're
is a
not
separate
interpreting
treaty.
it. We're simply saying that Trinidad and Tobago ought to comply with its obligations under the CLE agreement. Is that an interpretation?
Yes, Your Honors, to the extent that the CLE agreement does not consider this court's jurisdiction in its provisions, and it should be respected as it is as much a treaty as the RTC, yes, that would amount to interpretation contrary to the provisions of the CLE agreement.
We can't say anything about it.
Pardon me, Your Honor?
We cannot say anything about it, about the CLE agreement.
No, Your Honors, based on the provisions provided.
Okay.
Maybe let me just cite paragraph 23 of the Rockhart case in 22, where we say the community finds its legal foundation in the RTC. As with all treaties, the RTC must be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of their object and purpose. Article 31(1) of the Vienna Convention on the Law of Treaties. This is the internal context, but together with that, there shall also be taken into account any subsequent practice in the application of the treaty which established the agreement of the parties regarding its interpretation, and any relevant rules of international law applicable, meaning binding, in the relations between the parties before us. And a little further on, the court says the RTC, it's pellucidly clear that the RTC cannot be interpreted in clinical isolation from public international law in general, and in this case, WTO law in particular, even though the community itself is not a member of the WTO. So there you have some contours how treaties that are binding on the parties, in this case, the CLE agreement is binding on the parties, can that have then some impact on our decision under the RTC? That is the question. And you are saying not as far as it amounts to a declaration.
Your Honors, whilst I understand the guidance and I appreciate it, if the parties have not clearly indicated that it was the intention of the RTC to guide, the CLE agreement, then by no means can the community extend its jurisdiction to touch the operation of an agreement and make or grant any declaration that was not agreed by the parties. And in this instance, there is no evidence that the parties of the CLE agreement intended that the provision made in the RTC should interfere with the independence and the object and purpose of the CLE agreement. Therefore, whilst I appreciate the guidance, I reinforce the defendant's submission that the CLE agreement, as stated by this Honorable Court at paragraph 18 of the Jason judgment, is an independent treaty and cannot then interfere with or cannot be interfered with by the RTC or this court's honorable jurisdiction without the parties indicating such or it being otherwise established.
Ma'am, we understand that there's no dispute mechanism in the CLE agreement, and therefore it may mean not just that the states of St. Lucia and Grenada may be sent away empty-handed, but Mrs. Khalid may have nowhere to practice her law. What do you suggest would be the correct thing to do in those circumstances?
Well, Your Honor, if I may address the latter point first, by all means, Mrs. Khalid will have an avenue to practice law in accordance with our agreement. Respecting the independent operation of the CLE, she will be able to practice pursuant to Article 4 of the CLE. So the CLE agreement, in its independent operation, does make provision for her. And having its entrenchment and its provisions does not prevent this, the claimant or any claimant from seeking redress. However, we submit that this court's jurisdiction, based on its limitations, is not the correct means of redress.
The Court of Appeal of Trinidad and Tobago was not a happy place for Mrs. Hadid, Miss Hadid, when she went there. Is there any other place for her to go apart from what you say about Article 4?
Well, Your Honors, the matter at hand is this court's jurisdiction, and we submit that this court has no jurisdiction. And if that is a matter to be decided, it is for the community member states who are parties to the CLE agreement to collectively meet and determine how to provide redress for a claimant such as Mrs. Khalid. It is not for this court to act in ultra vires of its jurisdiction and of the CLE agreement to therefore step outside of the RTC and supersede on the basis that it is assumed that there is no redress. It is for the parties who are the holders of power of the CLE agreement to act accordingly.
Thank you.
But these are not clinically isolated circles. You know, the CLE was meant to facilitate the education of Caribbean legal practitioners. And when so educated, they are able to provide legal services. The RTC also has carved out a space for nationals of this community to offer different kinds of services, including legal services. So is there not some umbilical connection between the CLE, which allows for the emergence and qualification of people who can offer legal services, and the reservation by the RTC to CARICOM nationals of the space to offer that legal service? And if we are the court superintending the operation of the RTC, do we not have some responsibility to see how those two circles overlap?
Your Honors, the defendant submits that the reservation outlined in the RTC is in fact not being contravened by Section 15(1)(a). As Mrs. Khalid provided, she satisfies the provisions according to the independent operation of the CLE agreement outlined in Article 4. She will be able to provide services, and we in Trinidad and Tobago welcome her to provide services, provided she satisfies the respective provisions. So the RTC articles are not being intervened with. She's free to provide work, free to provide services. However,
But she argues that Article 7 is being contravened.
Your Honors, Article 7, as argued by my senior counsel, is not being contravened on the basis that the nationals in Trinidad and Tobago have an entitlement to state patrimony and an entitlement to nationhood, and Section 15(1)(a), which in fact I will soon ask this honorable court to allow me to move to my second point as time is elapsing, has found that if this court even finds that it has jurisdiction, the defendant rather has not breached its obligation, as it in fact complies with the CLE agreement and its RTC obligations.
Yes, I noticed you have mentioned patrimony a couple of times, including your senior attorney, and I do take the point, the time is going. I just wanted to draw your attention to the fact that in the preamble to the revised treaty, it does provide that the parties resolve to establish conditions which would facilitate access by their nationals to the collective resources of the region on a non-discriminatory basis. So I just wanted to put that out there, that the patrimony to which you speak, one of the objectives of this experiment is to allow for all nationals of the community to have equal access on a non-discriminatory basis. But sorry, I know you want to go on to your second point.
Well, Your Honor, I actually appreciate that question, so thank you, because it leads me to my second point, that the member state, the defendant of Trinidad and Tobago, has not breached its obligations under the CLE agreement or the RTC, because as you have pointed out, the LEC is an instrument that facilitates regional growth, regional integration, regional practice, and by enacting and operating through Section 15(1)(a) of the LPA, literally and teleologically, the member state gives recognition to the regional instrument being the LEC, whilst balancing its state autonomy, which the RTC also tries to protect by allowing only nationals to be benefited by the alternative provided in Section 15(1)(a). So if this court does find that it has jurisdiction, by no means has the defendant state overpowered the jurisdiction of this court or the jurisdiction of the CLE agreement, as the LEC is still the only instrument that allows CARICOM nationals to practice regionally. What the member state has sought to do is utilize the additional qualifications permitted in the CLE agreement to enable its own nationals to benefit and to build the nation of Trinidad and Tobago, and not to be hindered by the limitations that were provided as a result of the restrictive interpretation which the claimants have attempted to submit to this court. And by virtue of this, I reiterate that the jurisdiction of the CLE agreement is in fact outside the scope of the RTC. However, if this honorable court finds that it has jurisdiction, the interpretation of the CLE agreement should be that states are in fact permitted to provide alternative bases. And Your Honor, just to...
Doesn't it say additional?
Yes, Your Honors, and Article 31, which...
There is not a difference between additional and alternative?
Your Honors, I would have to submit no, because on the rules of interpretation of treaties, as you would have referenced earlier, based on Article 31 of the VCLT, in interpreting a treaty, you must first look at the plain and ordinary meaning. And the plain and ordinary meaning of the word additional may be taken to mean alternative. And to confirm this plain and ordinary meaning, I refer to Article 31(3)(b) of the VCLT, which says that to confirm a plain and ordinary meaning, we may refer to subsequent state practice of one or more parties. And, Your Honors, not only has the defendant in its subsequent practice interpreted additional qualifications to mean alternative bases, but further to this, the second claimant in their section 17(2) have also interpreted the plain and ordinary meaning to be alternative bases. So on this basis, the defendant submits that it is provided in the CLE agreement that we may permit our nationals to practice within or enacting member states. And of course, Your Honors, this is the basis on which the defendant reiterates that in accordance with upholding regional integration while balancing our state autonomy, we have complied with the CLE agreement. And again, this submission is only if this court finds that it has jurisdiction, because the most important case that I would like to leave this court with is that, respectfully, this honorable court has no jurisdiction to preside over a matter regarding the interpretation and application of the CLE agreement, as it is a separate treaty. And further, in paragraph 17 of the Jason Jones judgment, this court has found that it has no jurisdiction over the council. Therefore, it follows that this limitation cannot now be broadened to include the CLE agreement that governs the council. And further, Your Honor, this honorable court cannot grant the claimants the remedies being sought because the CLE agreement is outside the purview of this honorable court. Therefore, quoting Jason Jones, what could then be the point of the declarations being sought by the claimant?
I think we get the point.
Okay, Your Honors. Well, I have succeeded in making my defendants defending my clients, pardon me, and at this point, if I can be of no further
Well, there's one very small point, and that is that when you spoke about subsequent practice, and you said by even one state, I think just for the record, Article 31 of the Vienna Convention, paragraph 3, subparagraph B,
yes, Your Honor,
speaks about subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation. So it's not just the practice of one party that is of assistance in the interpretation. That practice has to grow into an agreement amongst all the parties that this is how you interpret the treaty. Yeah, thanks.
Thank you very much.
Thank you, Your Honors.
Do the claimants want to reply? Replies are always short, as you know.
Yes, very short. Difference in treatment was one of the things that was brought up. And if you look at the case of Emmen against College, Van Burgermeister, it's also a European case, and I'm having a little trouble pronouncing the N. Wenverdershaus van Den Haag. Hope I did that well. The defendant does not deny differential treatment, and in their submissions, they do not deny that differential treatment without justification amounts to discrimination. We have said that the defendant has failed on its two-limb justification test. Reliance on the Attorney General's reasonings 23 years ago is not relevant. And the claimant has shown that they have been prejudiced in exercise of their community rights. And despite having other alternatives, the defendant chose a knee-jerking response in respect of a solution to their alleged reasonable, justified use of Section 15(1)A to discriminate against the brothers and sisters of neighboring CARICOM territories, contrary to Article 7 of the revised treaty, and which undercuts the furtherance of CSME. And in this regard, I think that the claimant is correct in stating that Trinidad and Tobago has discriminated against her on account of her nationality by operation of Section 15(1)A of the Legal Profession Act. And the court is entitled, the court is a guardian of the RTC. The court must adjudicate on matters that touch and concern the revised treaty. And because the CLE agreement does not include the revised treaty, does not mean that Trinidad and Tobago can carve out exceptions to observance of the obligations under the revised treaty. We have a slew of case law which lets us know and confirms and reiterates and underlines and bolds and highlights the power that the CCJ has to remind member states about their obligations and to remind member states that where their domestic legislation runs contrary to the revised Treaty of Chaguaramas, that it must be brought in line with it. So the question still remains whether or not the justification put forward by the defendants is going to withstand this honorable court's scrutiny. And it is my submission that it cannot. It will not. It has not. If it pleases the honorable court, this is the end of my rebuttal.
Thank you very much. I'm looking at the time. It's later than we would have expected. I think we will need some more time to deliberate. I think we are supposed to start at 3. That would give us not really much time. So I suggest, I'm not sure where the Master of Ceremonies is, but I would suggest we reconvene at 3:15. Then we will, of course, give our comments on the performances by all the participants. We will indicate in which group there is a winner as far as we are concerned, and then we will leave it. Of course, we will give our findings to the organization, and they will then announce, gradually climbing up to the highest, who is the winner of which particular award. So that is the procedure. So we'll adjourn and we will come back at 3:15. Madam Registrar?
This court is adjourned.